Amen. Shout for the goodness of the Lord. Every time I hear that song, it doesn't make any difference how many times I hear it. It makes me think of how good God is and for numerous blessings we as his people receive from him every single day. This time I'm going to ask if just bow our heads as we ask God's presence in this meeting. Merciful Heavenly Father, we're indeed thankful for this Sabbath, for this afternoon, that we can come together to share and disseminate vital information. We ask that your divine presence we manifest in our midst in the wonderful name of Jesus. We say, and we thank you in advance. Amen. Good afternoon, everybody. My name is Dr. Alan Martin, and I have the distinct privilege of serving as the Public Affairs and Religious Liberty Director for the Northeastern Conference. We welcome you to this Part 2 program that we actually promised to provide and bring to you. We have been looking at this matter involving the Sabbath case at the Supreme Court, and we're certainly happy that you've come back to join us. The last time we didn't know so many people were going to be joining us, and our actual program was recorded, placed on YouTube, and we had as many as 70,000 viewers. And we're delighted to see those of you who are here this afternoon. We do recognize that it's summer and there's a lot of things going on, but we're delighted to see those of you who are here. And we bring greetings to you from our illustrious president, Dr. Abraham Jews, our executive secretary, Dr. Eldine King, and our treasurer, Elder Brian McDonald. We're so happy that we have this opportunity to present this wonderful program to you. And at this time, I just want to recognize my esteemed brethren who've come to join us from the higher levels of our organization. I'd like to first ask our Paul director for the NAD, that's Orlin Johnson, to say a word, and then from our very own union, Elder Charles J. Usey. So at this time, let's hear a word from Elder Orlin Johnson. Say a word to us, sir. We're glad you came from North American Division to be with us today.
Well, thank you, Dr. Martin, and it is a pleasure to be here today. And I want to thank you and the Northeastern Conference team for really keeping this issue out front. This has been an issue that really has taken on, I would call, more than an Adventist point of view. It's taken on a worldwide issue as it relates to the question of religious freedom. And I think these are the types of opportunities in which we can go out and really keep our parishioners and the world informed as to what's going on. And it's an honor and a privilege to be able to be with this team of scholars that have been working on these topics for decades. This is not a new group to the table. This is a group that's been around for quite some time. And I just think it's an honor and a pleasure for all of us to get together. And thank you for having us. Thank you for hosting this, and looking forward to what we can do to really keep moving God's mission forward with his people.
Thank you, sir. Elder Charles Usey from the Atlantic Union Conference. Your turn, sir.
My good friend, Dr. Martin, the officers of the Atlantic Union are strongly supporting this program this afternoon. They're aware of it. They appreciate the effort, the time that you put into this program and to so many new initiatives within the Northeastern Conference. I believe your conference is leading the way in many efforts, and we look forward to great things from you. God bless.
Thank you so much, sir. At this time, we're going to have a little music, and then I'm going to turn it over to my very able associate who works with me, Dr. Lawrence Brown, one of the greatest public affairs leaders in our work in North American Division, a wonderful man that he does so much as we work together as a team. And I'm going to ask for him and Elder John Ashmead, our associate director of the Atlantic Union. They're going to be the gentleman that's going to be taking this program and sharing with us along with the wonderful scholars who've come on here as we deal with this issue.
Dr. Martin, I think you went to another song.
Yes, sir. Go ahead.
Beloved, this afternoon, we are thankful for the opportunity to be together again. We are thankful that this will be closer to a wedding reception than a funeral repast. I want to introduce the person who's going to quarterback from here on out, take us through. That's none other than Dr. John Ashmead, who serves as the Associate Director for Public Affairs and Religious Liberty for the Atlantic Union Conference. Much sought after speaker, someone who presents well, and I always enjoy listening to his take on certain things. He's going to rally the troops, so to speak, this afternoon, and he will be moderating the group as we go. So without further ado, I'm going to turn it over to him. And Ashmead, I want to thank you for in advance for your leadership this afternoon. Take it away, my friend.
Thank you, Pastor Brown. And first, before we begin the discussion, I just want to take a moment and to commend the PARL team for the Northeastern Conference for staying on top of this issue and bringing us together again, and for leading. We are so grateful for the partnership with the Atlantic Union that you have fostered, and we are looking forward to greater and bigger things to come in the future. Just a couple of housekeeping items before we start. First, if you could do us a huge favor, as this discussion takes place, if you're not a member of the panel, if you could keep yourself muted, that would be greatly appreciated. And, you know, at the end of the discussion, we certainly intend to try to have answer questions. And so, you know, feel free to post your questions in the chat. Someone will be monitoring, and we will try to pick out questions based on themes, and hopefully we'll try to address all the issues that you have. This afternoon, we have a panel of 4 people. First, I'd like to again introduce Dr. Nicholas Miller. He is a professor at Andrews University Seminary, and he's teaching at Washington Adventist University. At the present time, he's an author and constitutional law expert. Next up, we have Bettina Krause. She is an attorney and an outstanding writer and editor for our Liberty magazine. We also have Orland Johnson, who is the Director for Public Affairs and Religious Liberty for the North American Division. He's a former partner in a law firm. He has taught at the eminent Howard University School of Law, and he's just an all-around good guy. So we're certainly happy to have him here this afternoon. And finally, we have Charles Usey, who is my mentor and friend, and he is the Director for Public Affairs and Religious Liberty for the Atlantic Union. So again, we are going to start out with some questions to discuss the Groff versus DeJoy case. Many people are happy with this decision. They feel that it is promoting a better understanding of what employers need to do when they are accommodating religious accommodation requests from employees. And so let's take a look at this decision and see if it's good for us or if it's bad for us. I'm going to start with you, Nick. The first question I have, just, you know, as we're getting started, can you remind us of the facts of the Groff case? Tell us about Mr. Groff and the circumstances that led him to file suit.
Yes, sure. It's good to be with you, John, and the rest of your colleagues. Gerald Groff is a Sabbatarian. Now, in a group largely made up of Seventh-day Adventists, I should probably explain that. When people say they're Sabbath keepers, we often think, oh, that must mean they keep the seventh-day Sabbath. But that's not always the case. Sabbatarian is a word that is used also for Sunday keepers who believe in keeping the day holy. So many Christians will go to church on Sunday, but then they'll go shopping or to sports or to work afterwards. But evangelical Christians, such as Mr. Groff, who believe that the Sabbath should be a day of rest, much as Saturday Sabbath keepers rest and don't work on theirs, are also called Sabbatarians. And Christianity Today had an article about Mr. Groff where they described him in this way, as a Sabbatarian. He was a missionary. He's quite a sincere Christian. I believe it was in Africa for a few years, but he came back to the US and needed to get a job, which he did in 2012 in a rural county in Pennsylvania. At the time that he got his job, the post office did not operate on Sundays. So he did not have any problems in being hired and having his Sundays off. But about a year into his tenure, the post office entered into a contract with Amazon. And Amazon believes in delivering packages 7 days of the week, and they need help, especially during holiday seasons. And so they entered into an arrangement whereby US postal workers would deliver Amazon packages, including on Sundays. And now, suddenly, Sunday shifts became a reality at his post office. He tried to put this off by shifting to another carrier route that didn't have an Amazon contract. And that worked for a while, but then they too entered into an Amazon contract and had Sunday deliveries. He began to be penalized for missing Sundays. He ran out of sick days and the ability to call in and get off. He was suspended for 2 weeks. And then when he came back to work, he realized that he would just inevitably accrue enough points to lose his job. And so rather than have that happen, he resigned and got another job. He had contacted religious liberty lawyers. And ironically, this is how Seventh-day Adventists become part of the case. Usually we're involved in trying to get our Sabbath off. But our friend and colleague, Alan Reinach, who's the Public Affairs and Religious Liberty Director in the Pacific Union, has developed a national reputation in his handling of Sabbath accommodation cases. And his Mr. Groff's case was referred to Alan. And so a Seventh-day Adventist was part of this case as an attorney rather than the plaintiff. And Alan did a fine job at representing him in the lower court, though he was not able to prevail under the existing standard, which I think Bettina Krause is going to tell us more about, that the post office was found to not need to accommodate his standard because of the test being rather weak. De minimis language is used in that test. And so they lost below. A evangelical First Amendment group became involved in helping with the appeal. They lost in, I think it was the 10th Circuit, and then it was appealed to the Supreme Court. And so put squarely before the Supreme Court was the case that we as Adventists had been trying to bring for some decades to try to strengthen the Title VII test for religious accommodation. And ironically, an Adventist was there as a lawyer, but not as the plaintiff, and the case was about Sunday. But the results of that case and that test would directly impact Seventh-day Sabbath keepers as well. And so that's the background. That's where it was when it got to the Supreme Court. And I'll let you ask your next question.
Thank you. Thank you. That's a good review of the issues. So Bettina, Dr. Miller mentioned that Adventists have been trying to get this issue before the Supreme Court for some time. We were concerned about an earlier case that really limited our abilities to get religious accommodations, and that case was the Hardison case. Can you just tell us what the holding was for the Hardison case and why the Supreme Court felt the need to review its holding in Hardison in the Groff case?
Yes, sure, John. It really does. This case, Hardison, TWA versus Hardison, it really does set the stage for everything that we're going to be discussing this evening. It involved another Sabbatarian, not an Adventist, but a member of the Worldwide Church of God. Back in 1977, the Supreme Court took this case of this gentleman, Mr. Hardison, who was fired for refusing to work Saturday shifts. Now, at the center of this case was a question of interpretation of a certain phrase in the 1964 Civil Rights Act. And under Title VII of that act, it says that an employer has a responsibility to reasonably accommodate the religious needs of their employees, unless to do so would create what is called an undue hardship. So that is the key question in the Hardison case. What does this phrase undue hardship mean? What sort of hardship are employers going to need to show in order to be excused legally from their responsibility to provide a religious accommodation? And the answer that the court gave back in 1977 in the Hardison case, well, it was frankly disastrous, and it has had a lasting and profound impact, not just for Sabbath keepers, but for many other people of faith over the past 5 decades. So the court said this, that it said that to require TWA, Trans World Airlines, the employer, to bear anything more than a de minimis cost in order to give Mr. Hardison Saturdays off, that would be an undue hardship. So in other words, anything more than a trifling or insignificant hardship is enough to excuse an employer from their responsibility to provide that religious accommodation. There was another aspect of the case, which I'm sure we'll get to, which looked at how Title VII operates within a unionized workplace. And the court held in Hardison that seniority systems, which are often contained within collective bargaining agreements in a unionized environment, they can't be violated as part of an employer providing a religious accommodation. So that makes the situation even harder for a religious worker. So in terms of this de minimis standard, we can all, it was entirely foreseeable how this was going to play out. There was really, for almost 5 decades, no real legal incentive for employers to accommodate the religious needs of their employees. This was a very low threshold. And if you really want to understand just how significant this low threshold was, just look at the data. I mean, there was a study done on appellate cases from 2000 through 2020, the 20-year period, where they looked at all the cases that dealt with religious accommodation claims under Title VII. In those cases, the religious employee lost 86% of the time. I mean, that's an incredible loss rate. And the data also shows that this de minimis standard disproportionately impacted minorities, religious minorities. Seventh-day Adventists, where 0.5% of the US population. But when you look at the cases where Hardison has been expressly applied, Adventists make up almost, well over 20% of the plaintiffs in those cases. So the impact of this low threshold was broad, and it was very painful for people of faith for many, many decades.
Thank you, Bettina. Now, why don't we bring Charles in? And now, Charles, I know that you listened intently to the oral argument before the Supreme Court. Why don't you do us a favor, just describe very briefly that argument, what your perceptions were of it, and are you surprised? Asking 2 questions in one. Are you surprised with the outcome, where it seemed like a unanimous decision from the court, reversing its prior holding in the Hardison case?
John, we haven't seen too many unanimous decisions concerning the First Amendment and religious liberty. You can see how divided the court is by just reading the opinions in the other religious liberty case that was recently decided, 303 Creative. It was if the majority and the minority were fighting each other. They didn't hold back any punches. And we don't have a court that's unanimous in religious freedom. We don't even have a country where religious liberty groups are fully in support of religious freedom. For instance, years ago, our church was involved in forming what's called Americans United, separation of church and state. That organization, which we backed for a long time, this year, they were not in favor of the position of our postal worker. We find that when we talk to people who are experts in this area, religious liberty leaders throughout the country, they were not expecting a favorable opinion. You asked about the oral arguments. The oral arguments showed that the court was skeptical of overturning Hardison. When we talked about it as a group, the directors of Carl for the different unions, we didn't think that we were going to win. In fact, our friend Todd McFarland, who's in constant contact with religious liberty directors of other organizations, said it didn't look very positive. So when we got a 9-0 decision, we were ecstatic. And today should be a day of celebration. Maybe we didn't get everything that we wanted, but I think we have good reason for thanking God for the way the opinion turned out.
Thank you, Charles. So, Orlin, Charles mentioned that, this outcome was, somewhat unexpected. And when we looked at the Hardison decision, we saw a clear divide between conservatives and liberals. The liberals on one end, the conservatives on the other. What do you think happened in Groff that led to a unanimous decision by liberals and conservatives, considering how in other cases this year they have been deeply divided and quite vitriolic with each other?
Well, one thing that's just very interesting, it's amazing what 45 years will do. As time starts to go on, we start to see an evolution in many ways. I mean, when you think about it, Bettina brought up the fact that this was a case that took place in 1977. And I'm probably going to use a phrase that many of us have not heard in a long time. That was during the Carter administration. So the mere fact that we're talking about how life has changed over all these years is already a first step in understanding the change that has taken place. The flip side of this is back in 1977, the concept of religious freedom was actually considered to be a liberal issue. It seemed to be an issue where the liberals were the ones who were, quote unquote, protecting the sacrosanct of individuals and their religious freedom. And when you look at the dissenting opinion that was done with Hardison in 1977, it was Thurgood Marshall that actually had some of the toughest statements talking about the fact that this decision was going to obliterate the understanding of what Title VII was supposed to be about. So I think between the evolution of time and things are moving in a different direction, I think the other point Bettina raised, which was actually, in my opinion, more of a red herring during that case, was the whole idea of what was going on with the seniority system. It seemed as though the courts were very concerned about doing anything that from an employment law standpoint would cause a seniority system that had been, quote unquote, negotiated during a collective bargaining. It's almost as though it was a unionized muscling that was taking place in this case, as opposed to really focusing on the issue of whether or not someone has, quote unquote, protection under the law. And so I think what we have is we have a culmination of one, the idea that the protection of religious freedom has not become simply a quote unquote liberal issue. As a matter of fact, 45 years later, most people will say that that's actually a conservative issue. And I think the combination and the transition moving in that direction has caused this, what I would call, a perfect storm of activity. And whenever you have a unanimous decision by the Supreme Court, I think you have to agree that there was a perfect storm that took place here. But I think one other point I think that really made a difference here is we find ourselves working with a court, and I'm sure others like Dr. Miller and Bettina will even weigh in on this, where when many of us were in law school, the idea of just judicial restraint was considered to be a main aspect of what you would be looking for from a Supreme Court in general. And even though this is a decision that looks out in large part and probably is a positive thing as it relates to Seventh-day Adventists and other religious groups, that I think all it really also does, it kind of sets a new standard and a new table for where the fight is actually going to take place. And the reason I say that is because we now have what some would say would be a reversal of Hardison, but I think this particular court will tell you that it's just more of a clarification of Hardison, where instead of looking at it from a de minimis standpoint, they want to talk about it more from a substantial cost perspective and moving away from the concept of how this impacts the employee to really more of a focus on how this has really shown to be a negative impact on the company itself. And I think that in and of itself is what caused a lot of this activity to begin to transition. But I think we are still going to find ourselves talking about how this is still going to process forward, because much of this is still going to be decided on a case-by-case basis on what the employer is, how the employer functions, and how that is going to be able to substantiate whether or not there's a substantial cost that's taking place or not. So on one hand, I think this was a great decision, but on the other hand, I also think that this is preparing us for what some would call round 2 and 3 of the next heavyweight fight as it relates to religious freedom.
Awesome. Thank you, Arlen. So you've sort of begun to unpack the holding of the court. Why don't we get into it in detail? And I'm opening this question up now to the entire panel. What is the holding of the court in Groff v. DeJoy?
So I guess since I'm the one that has spoken the furthest away, maybe I'll jump in.
All right.
In the court really kind of split the baby between what both sides were arguing. There were 3 possible ways that the court could have gone. Bettina set out very nicely the de minimis standard in the Hardison case. Anything more than a trifling burden would mean that the employer wouldn't have to accommodate the Sabbath keeper. But in Hardison, they also used language of substantial hardship, which to the lay ear sounds quite a bit different than de minimis. And the court argued, the plaintiffs in the case argued that de minimis should not be the standard, but neither should substantial hardship. They wanted another framing of it called significant hardship or burden. And that tracked something in the law under the American with Disabilities Act, which has used language like the significant hardship for many years. And there's a whole case law that develops that. So you had the government arguing for de minimis, for the standard remaining the same as the Hardison standard. You had the plaintiffs arguing for significant burden and hardship. And what the court did was sort of in between. It said, look, the de minimis language is clearly not meant to control the Hardison decision. We think that the substantial hardship language of Hardison is correct, but their gloss, this de minimis, was not correct. And so, and especially the concurring opinion tries to argue that Hardison really isn't overruled, it's just clarified. But the reality is, in rejecting the de minimis language, they did overrule at least that part of Hardison and embraced substantial hardship without the lens or prism of de minimis, saying substantial hardship has to be real burden and hardship. And it certainly, things like paying infrequent overtime, spending time and effort on swaps, none of that is going to be substantial hardship. Now, they didn't agree to the significant hardship, the ADA standard. So that's why the concurring opinion could say Hardison hasn't been overruled. But the reality is most practicing attorneys know that when language like this changes, when de minimis is rejected, that does offer, and the court itself said, yes, perhaps much of our precedent won't be overruled in this era. The EEOC interpretations, many of them will stand, but they acknowledge that some of them wouldn't, and that this de minimis language has gone away, and now you have to focus on substantial hardship. And as Orlin has pointed out, future cases will flesh out what this substantial hardship actually means. But it's going to be an improvement, we can say, with almost no doubt.
Yeah.
So let's just stay with this whole issue of what undue hardship now means. And you know, I'm struggling to understand how the court could distinguish between the you know, what hardship means under the ADA and under the, you know, religious accommodation standard. How can the same word have two different meanings?
Well, there's a different adjective. Under the Title VII, it's substantial hardship. Under the ADA, it's significant hardship. So they're both hardships, but the adjective is different. What's the difference between substantial and significant? I'm not quite sure, but they are two different words.
Right. I mean, John, it does sound like just an issue of semantics, you know, playing with words here. And I think, as both Orlin and Nick have pointed out, we're really going to have to wait and see how the lower courts take this ruling and start applying it before we really understand what the new contours of this new heightened protection for religious employees is going to be. I think it's important to point out that the Supreme Court's decision made clear that when this new test is applied, that courts are going to have to look at sort of a net impact on the business. So in other words, applying the test in, for instance, a situation where there's a 20-person hardware store down the road, as opposed to a high-tech, you know, multi-billion-dollar, 5,000 employee multinational. I mean, the court has made clear that there's going to be sort of a weighing process here. How much does the proposed accommodation impact the conduct of the business? And that is another area where we're going to have to see how the lower courts apply that. And that's another area where, as religious freedom advocates, we're going to have to be vigilant in making sure that is applied and understood in a way that is as expansive and protective as possible for people of faith.
So I wanted, Orlin mentioned Thurgood Marshall's dissenting opinion in Hardison, and I want to go back to Justice Marshall's dissenting opinion. He noted that there was a point where Title VII was amended by a Senator Jennings Randolph. And Senator Randolph was a Sabbatarian, as Nick mentioned. And he noted that the purpose of Title VII was to protect the religious rights in the workplace for minority religious practices. Do you think that the court has sort of moved away from that view? And is that a view that that the court should return to? And you know, that this provision is there really to protect the minority from majoritarian activities?
Well, you know, John, it's kind of funny that ironically, you, myself, and Thurgood Marshall are all graduates of the same law school. And one of the things that we were really pushed on was the whole idea of really understanding the intent of a statute. And being in Washington, D.C., the intent of what legislatures were actually thinking about when laws were crafted were supposed to really give you a clearer understanding of what the whole purpose was. I think what Thurgood Marshall was actually saying that portion of Title VII got should have been very easily understood as to what was meant, because the individual who crafted the language was really putting it in place to protect individuals such as himself. But I think the other point, and Nick kind of alluded to it, it would have been very easy for this court to decide that the language they were going to use would have been significant as opposed to substantial. And in my mind, what that says is they were not ready to go all the way and say, let's just utilize the ADA standard. I think that actually this was purposefully done to be a step removed from the ADA standard, with the idea that we want to see a new standard gets created through the flushing out of all of this activities. And so I think in my mind, part of what I think Thurgood was saying was, I think it was pretty clear that the intent of this statute was to protect an individual like this senator who was a Sabbatarian. But I think the current court wanted to make clear that we do want to protect these type of individuals, but we're not quite sure if we're ready to take on the quote unquote ADA standard of protection. We think there probably is what I would call a ADA light standard that they hope actually gets flushed out when this is all said and done. But that's just my personal opinion of how I see it.
Charles, why don't we get you involved here? You know, what about what that senator tried to do? He tried to protect the religious freedoms and rights of Sabbath keepers. Should we become politically involved to sort of preserve and protect the freedoms of people who look and act and feel like us?
I think we should be involved to protect this as a part of civil rights. We support people because of color or religion or national origin or age or their sex. And it's a part of loving others and doing to others as we want them to do to us. I don't think we need to back off from saying that people of religion should be respected and they should not be discriminated against because of their religious beliefs and practices.
Awesome. Anyone else want to add to what Charles has just shared?
Well, I think, John, this is also, I'm sorry, go ahead, Bettina.
Oh, no, go ahead, Orland. You're right.
I mean, I think the point that that Charles has just raised, and we should be spending our time and energy looking out for the protection of our fellow man. I mean, if you look at this from a Christ-centered perspective, and being more like Christ is really looking out for those who have been disenfranchised, those who have been taken advantage of, you know, looking out for those who are quote unquote the least of these, I think is part of the job that a true Christian should engage in. And so those who get a chance to be involved in that battle from a legal perspective, I also think that's what we've been called to do. And I think sometimes too many of us are willing to stand on the sidelines because we think to engage is to really overstep what is expected of us, as opposed to understanding that the voice that we bring to the table should be part of the fabric of all of these decisions as they move forward.
So John, let me just piggyback on that. You know, as Orland says, I mean, that is sort of a theological framework for why we should be involved in trying to protect the rights, not just of ourselves, but of every person, regardless of what they believe. There's also a pragmatic element too. You know, throughout our history, Adventists were very quick to understand that, you know, when it comes to civil rights and religious freedom, all boats rise together or fall together. And so when you are advocating for the right of someone to wear a hijab in the workplace, or to, you know, to take time off for prayer, Muslims taking time off for prayer, or, you know, to wear a beard, or whatever religious accommodation it is, regardless of how different it is to our beliefs, we are actually strengthening and broadening religious freedom for not just ourselves, but for society in general. And so, you know, we do have that theological mandate that Orland spoke of, but we also understand that it is, you know, very much a pragmatic strategy to cooperate with everyone.
Awesome. I want to again highlight another area of Justice Marshall's dissent in the Hardison matter. He proposed 2 accommodations to the Sabbath keeper and noted in his opinion that both would have violated the collective bargaining agreement, but then said, you know what, it would have violated this agreement, but it would not have had any impact on any employee. The court in Groff seemed to affirm the majority's opinion in Hardison that, you know, the collective bargaining agreements are sacrosanct and cannot be violated. Looking at these two issues, who's right, who's wrong? Should the collective bargaining agreement trump religious accommodation, in your opinions?
So I don't think so, John. And I think now we're getting to, you know, we've kind of celebrated this case as a unanimous decision in support of religious freedom. But I think this very point shows some of the limits and the weaknesses of the decision. You know, they didn't embrace significant hardship. We've already talked about that. But then out of the gate, they just said union, collective bargaining agreements, that's going to be considered a substantial hardship. And, you know, I just think that that isn't necessarily, you know, effectively, we're saying that unionizing activities, which is kind of a collective effort, should always and everywhere and under all circumstances be considered superior and more valuable, and should always win when they come into conflict with individual conscience. Well, I have trouble with that position. I mean, the very notion of a Bill of Rights suggests that in a democratic society where the majority rules most of the time, that at least in areas of certain fundamental areas of conscience and of speech, that the majority should give way sometimes. And, you know, as Marshall pointed out, the collective bargaining agreement could have been violated without negatively impacting any other employee. So why are we making union rights? You know, the First Amendment protects our most valuable rights. Well, I can read the whole First Amendment and there's nothing about unions there, right? And I'm not saying unions might not have some value, and you know, we'll have this discussion about the relationship of our church to them. But I find it somewhat disheartening that just at the front, they say union agreements always win over matters of individual conscience. To me, that's putting the collective ahead of the individual under all circumstances. And it, in a sense, is anti-American from the outset.
Anyone else want to add to what Dr. Miller shared?
Well, you know, Nick, I think what you've hit on right there, it's almost as though we've got a decision, but then there's a clear restriction that you're hit with as soon as you get the decision. You know, it's almost like saying, well, we're going to give you the whole cake. Oh, but by the way, you don't get to eat the butter and the flour is not yours as well. So, you know, it becomes this irony where you kind of say, I love the decision, but one of the barriers that sits there at the beginning of the process is already going to cause the whole conversation to be very different going down the road. And, you know, and that's why, you know, one of the uniqueness of politics, and I guess that also begs the whole question, you know, the Supreme Court is supposed to be that third branch of the government that's supposed to be the quote unquote nonpartisan or almost the umpire in the whole concept of how we kind of have the checks and balances that if the umpire now is starting to side with certain players in the game, do we have a real umpire that's really helping us to make the right decisions? And that's where I think it's going to start to get very, very tricky down the road. I mean, I wouldn't say that this decision really kind of leaned more in any particular religious direction, but I'm sure Bettina and Charles and others have seen a lot of people talking about, oh, and by the way, 7 members of the court are Catholics. You know, you start hearing those type of statements being made when they juxtapose other things. And sometimes the two have nothing to do with each other, but just the conversation itself almost starts to beg the question is, can you even trust what came from there? Because we're wondering about, you know, their legitimacy, and are they really the umpire in the game, or are they now starting to favor people because they have a quote unquote partisan connection? So I think all of that turns this into a little bit of a messy process, even as we move forward with what we're hoping to be more clarification.
Bettina, do you want to add to that?
Right. I mean, the theme that's developing here is that the decision in Groff is wonderful. It's overruled the de minimis. It's moved us in a positive direction. But the key point is that Orlin and Nick and Charles have made is that the fight isn't over. And this whole issue of seniority rights, collective bargaining, how is religious accommodation dealt with in a heavily unionized workplace? That's the next frontier. That's the next frontier of legal argument that we're going to have to engage in. So, these are all questions that are still open, and they're all questions that we're going to be engaging in going forward.
So let me just address this, or let's talk about this union issue and membership in unions. Many Adventists are part of professions that are unionized, and they are often confronted with, should I join the union? Because historically, Adventists have been against unionization and joining unions. And certainly in the past, I know that Ellen G. White has commented on union membership as well. And, unions in the past engage in a lot of negative, violent behaviors. I'm not sure that that's the case today. So from the panel members, what are your views? Should we reconsider our views regarding our members joining unions?
Well, I would say that we probably already have. I think the idea of what unions and being a part of unions may have meant, years ago has taken on a little bit of a different, viewpoint. I think there were times where many people thought if you were part of a union, that meant you must have been part of some organized crime operation that, was existing in some form or fashion, or you may have been involved in something that was not an organization that was deemed to be Christ-like in its activities. So I think even just the interpretation of what it means to be in unions, as it has really kind of evolved into how well do you look out for your employees? How well are you engaging in activities that are in the best interest, ensuring that children aren't being taken advantage of? And so I think even just the evolution of where a lot of that conversation has been with unions has caused us from a church to, in my opinion, unofficially have taken on a different viewpoint, even though you may be seeing some things that we obviously still have official statements from that perspective.
Well, and it is a live issue now. I think right now Loma Linda University is undergoing a lawsuit to the Adventist Medical School and Medical Center in California. Their residents are trying to unionize. The church is defending against it. And one of the arguments is that it's against our religious practices and teachings. It is a complicated issue. And when you go back and you look at what Ellen White and early church leaders wrote, it seems that the reason they were opposed to the unions was, as has been mentioned already, the violence that was often associated with unions. I think even the striking is a kind of act of coercion, right? When you walk out on a strike, you are bringing coercion to bear in ways that often can lead then to internal violence among the union members. If some people don't want to strike, you cross the picket line, you're harassed. I mean, that has still happened in the recent past. I think we have become far more kind of sensitive or nuanced, like employee organizations that don't strike. Sometimes they'll have the name union, but are they really unions in the sense that I don't have a problem with employee organizations. And we often only quote from Ellen White in terms of unions and our pioneers, and we don't quote from them about capitalism and unrestrained trusts and ruthless corporations. And we don't have a problem with anyone working for corporations, but you can't be a member of a union. Well, we need to read both sides, right? There was a problem with coercion on the labor side, but there was also a problem with overbearing and coercive behavior on the corporate side. And maybe we should have more to say about that today as well than we do.
Right. And, Nick, Ellen White did make some pretty no holds barred comments on you know, the exploitation of workers under unrestrained capitalism. So, you know, we shouldn't have a lopsided understanding of her comments on these issues. I think it would be also helpful for people to go back and look at an official church statement from, I believe it was 2003, which really laid out some of the biblical principles which underlie the church's traditional understanding of employee-employer relationships. And it is much more nuanced than I think many of us would assume. And it provides really an analysis that says, you know, we're a worldwide church, we're operating in different legal and political and cultural environments, and that all needs to be taken into account when we look at these questions related to employer and employee relationships and unions. So the issue is much more nuanced than I believe the conversation is generally made out to be.
You know, John, I think, you know, Nick starts to raise a point that gets very interesting when you start thinking about the capitalist society that we live in. One of the things that we haven't touched on as yet, and I believe that there was approximately 20 state attorney generals who actually sent in a request that this decision not move forward in favor of Groff. And I think a lot of that was along the ideas of, oh my goodness, what do I do in particular if I'm in a state where we have a number of positions that have to do with the hospitality industry that are working 7 days a week, and many instances shifts with 24 hours a day, that now we're talking about potentially having a couple 100 million people in the United States being able to call into their employers and say, hey, I'm not working on Sunday because that's my day of rest. And so how do you now start to say that we've got to balance now a union perspective? We have to balance now the fact that we're in a capitalist society where, for lack of better terms, it's about the money that you make and not about the money that you lose, and balance that in such a way that we now have a positive test that protects all of our individuals. So whether it's a union, whether it's the big bad corporations, somehow we have to make some type of balance here. And over 20 general councils and 20 attorney generals from across the country was saying, courts, please don't do this because we're not sure what the economic impact is going to be to us. So that's why I say the fight is still beginning, and how we start to see this, you know, kind of shape to still protect your local businesses to some degree, and also making sure that you're balancing it against, you know, making sure that people's religious freedoms are going to be protected. And to be honest, I'm not sure how it's going to play out.
So I'm looking at the time, and I want to leave some time for questions from our audience. But Orlin, you sort of touched on something that I think will cause people to think and think intently. Do you think that we're going to see, you know, the floodgates open with Sunday keepers across the country now seeking accommodation, Sunday keepers becoming Sabbatarians, as Nick mentioned, and seeking to get Sundays off?
Well, I have no crystal ball on this, but I think part of the reason that there were many that believed that this would have been a much tougher decision to move forward was because of the fact we were talking about Sunday instead of Sabbath. Many of you remember where we had the Walgreens, Patterson versus Walgreens case that we thought was going to get taken up to Supreme Court. There were many that thought that would be a much easier decision because the Saturday Sabbatarian is a much smaller population in the United States. So the fact that now you have potentially opened the door to a much larger population that can be claiming this, and I will be the first to tell you, I'm not very comfortable with courts determining the sincerity of whether or not I believe that this is really my Sabbath or not. That I think that balance is where it starts to get really, really tricky. And where we end up drawing the line, I don't know. We don't tell people, well, you used to be non-Adventist, quote unquote, last week, and now you want the Sabbath off. Well, you have changed and you've become a different person today, and, you know, new every morning, and every now and then this happens, and we still want to see people protected. So I don't know what the right answer is, John, but I do think that there's going to be a lot of messiness we're going to have to fight through with this.
Any other thoughts on that question? So Pastor Brown, I know that we are out of time for this section. I just have one final question that anyone can address. It took over 40 years to get Hardison overturned. What message does that send to us as believers as we continue this fight for religious freedom and accommodation in this country? Charles,
Well,
what are your thoughts?
I think that we need to give thanks to the Northeastern Conference because of the strong case that we have there from Mary Myers, who was a part of the Linden Church. You recall that Mary Myers decided that she wanted to work for the New York City Transit Authority. They allowed her to work for them for a couple of months, and then when she had unexcused absences, she had to leave. She went to court. It took 8 years to get a decision. And finally, when the decision came out, the court said, no citizen will be required to choose between piety and employment unless the pragmatic realities of the workplace make accommodation impossible. And the standard they came up with, they said the statute requires that employers must take all reasonable steps short of those involving undue economic hardship. And I know that that case has helped a lot of members of our church in New York City and throughout the state of New York. They would have lost their jobs. They would have not been accommodated. And it's been a great help to them. It's been a great help to Pastor Brown as he has represented a lot of these people. And these people today have work. They would not have had work had not been for Mary Myers of the Linden Church of the Northeastern Conference.
And any other thoughts?
Well, I think,
No,
John, the courts, I'm sorry, go ahead, Bettina, please, go ahead.
Okay. John, I think it does really highlight the value of Adventists working with other faith groups toward common goals. I mean, if you watched the oral or heard the oral argument and you heard Justice Alito, holding up a whole bunch of amicus briefs written by, Sikhs, Hindus, Adventists, Jews, a whole Muslims, and the whole religious community were coming together to support a principle of religious freedom. Adventists have been foremost or very important in this fight, but we haven't fought alone. And by developing those relationships with other faith groups, we make it much more likely that we will strengthen religious freedom in America.
Go ahead, Orlin.
No, I just would champion the same thing that, if nothing else, I hope that these matters let our church members know that we are out fighting for everyone's religious freedom. And in the idea of religious freedom, injustice for one is injustice for all. And the partnerships I think that we have developed and the friendships that we have developed in taking these cases on, I think cannot be understated in any way. Because if we were out there fighting by ourselves, I think we would be really behind the 8 ball in many ways that we cannot even imagine.
So Nick, I'm going to give you the last word. Is there anything that we haven't discussed or any final point you think is important for our audience to hear?
Well, I do think that's something that's been raised occasionally, and we haven't talked about it here, is that this decision kind of goes the opposite way of our eschatology, right? Don't most of our members believe that Sabbath is going to not be protected, and here we are celebrating a case that greater protections are being brought to the Sabbath. And I think it's worth pointing out, we did talk about the union factor. I mean, Ellen White talks about union principles overriding religious freedom. And here we have a court saying union principles should override religious freedom, right? Let's not forget that for a moment. It also is a case vindicating a Sunday keeping. Now, I think the implications are also good for Sabbath keeping, but is it a mistake or an accident that it was actually a Sunday keeper that was able to bring this change? And there's an indication that the court is interested in protecting the religious rights, especially of majority groups. And there's other cases that came down the same day, including the affirmative action case, which we don't have time to talk about here, but it would give some fuel to the fire that suggests, yes, this court is interested in protecting the religious convictions of Christians, but other civil liberties are going to have to stay in the background and not be protected. And as Adventists, we have to recognize that our Sabbath keeping is especially about minority rights and also about the fair and equal treatment of all people in a community. And while the Sabbath accommodation kind of won here in a sense, that other principles that we care strongly about in relation to the Sabbath may have been pushed back at the same time, and we have to remain alert to these other concerns.
And Nick, I just want to mention that we are going to have a later discussion on the affirmative action decision. And so I just want our audience to be aware of that. Pastor Brown, I'm going to stop here, turn it over to you, and allow you to take some questions from the audience. I know that we don't have a lot of time, but certainly we want to hear from those who have been listening in so far.
Well, the beauty of it is, as the questions have been coming in, I've been watching them, and in just about every instance, your later commentary actually addressed the questions that have come in, questions about unions and questions about how this impacts other groups, and so thankfully, it seems that we've had a nice flow here. And you literally just answered one of the last questions that came in, and that is that, yes, there will be a later program dealing with the affirmative action decision, as well as a program dealing with some of the LGBTQ issues that are coming in. So it's been a good time together this afternoon. I think it's been very profitable. I think what it really boils down to, as you've said, is in many instances, we're going to have to take a wait and see attitude, how it plays out, how the courts decide on some of the issues that will now grow out from here. And if anybody thought that we could exhale, if anybody thought we could stop praying, if anybody thought that we could stop, doing the work God put us here to do, let me disabuse you of that notion right now. We are in the closing moments of Earth's history, and things are going to rapidly escalate. Now more than ever, we need to make sure that we are developing a strong devotional life, developing a strong prayer life, developing the capacity to trust God even when we don't understand where he's leading. And more than anything else, the ability to hold on, believing that by and by, God is going to come and receive unto himself those who have chosen loyalty to him over everything else. Beloved, all I can say is fasten your seatbelts. And as we get ready to wrap up, we want you to say, stay tuned.
I'll wrap it up just
yes. Yeah, no, I was actually going to throw it over to you. We want you to stay tuned because there are some good things coming down the turnpike that you're going to want to be a part of. And on that note, I want to throw it over to Dr. Alan Martin, who will talk about that as well as any final appeal he may have.
Yes, thank you so much. We appreciate this very erudite, strong, well-trained, educated legal team we have that represents the Seventh-day Adventist Church in North America and elsewhere. I was thinking about, I do have a question or two that I'd like to put to you, and I'm really thinking about the average member. You dealt with the technical aspects and some practical aspects, but very technical legal. The person out there at this juncture who is, let's say, dealing with a Sabbath issue, and we have a couple individuals who were told by their employer that either they work on the Sabbath or they're going to lose their jobs. All right. My question to you is, how does this decision help them at this juncture? Well, how does it apply to them in the here and now? That's my question to the team. Or is there any relevance to help them with their present challenge? I do know, based on what you said, that even though a decision was made, it seems as if it's still fuzzy. You know, it has to be applied and all the rest. But I was wondering if you have anything to say to people who are in that situation right now.
Well, Dr. Martin, I'll say that regardless of this decision that has come down in Groff, from an accommodation standpoint, the law has really been fairly clear in terms of there is a responsibility on the part of the employer to provide some type of reasonable accommodation, assuming that it isn't, quote unquote, impacting it in a quote unquote undue hardship that we're now getting more, quote unquote, information on. We should not lose the idea and the onus that the way the law is crafted, the moment an employee makes clear to an employer that there is an issue from a Sabbath accommodation standpoint, it now actually puts the employer on notice that there's something they need to be starting to look to do to accommodate the employee. I think what has consistently been happening is employers try to give employees the view that you're asking for something special that we don't have to do for you. And it is just the opposite, that you are asking for something as an employee that has been protected from a legal perspective that you are required to do something about. And I think us utilizing these type of conversations and talking about these type of cases really is to hopefully help more individuals to understand that you have rights that you can utilize, but we do not need to be shying away in any way. We can move forward aggressively, and there is an onus on the employer to do something, regardless of what you've seen. And I think that's one of the points we have to keep making to the public.
Right. So, in other words, this member of ours who's been fired, lost their job based on this, their decision not to work on the Sabbath. They have recourse now because the court has backed it. That's where I'm going with this. For instance, now we can say to that member, say, look, based on this decision, the onus is on the employer to accommodate you, and you've been terminated. So therefore, legally, from a legal civil rights point of view here, you have actual recourse to fight this.
And I guess what I'm saying, Dr. Martin, they had actual recourse to fight this in spite of this decision. And that's where we want to make sure that people understand that this ruling does assist us as we fight through interpretations of what accommodation should be. But the fact that an employer should be looking to assist in a reasonable accommodation is already the law. And this really just strengthens us in terms of more arguments as we go down the road with this topic.
Right. And the reason why I'm raising that question is because we're seeing a number of members now having serious with being able to get the Sabbath off, and especially from the post office, which I in the past we perhaps haven't seen this, but they're beginning to say, look, you got to work on Sabbath. We have several cases in our conference, and that's why I'm posing this question, because I know there may be members out there who are on this program watching and listening for voice of reassurance and hope in regards to this. And that's why I raised it, and I thank you so much.
Absolutely.
Now, our editor, Bettina Krause, I'm going to bring you on. And I wanted to ask, in terms of future articles, that you're going to be dealing with this in the Liberty magazine. Am I correct?
You certainly are correct.
Right. Say a little word to us about that, because we're encouraging people. You know, as I said, we didn't have as many people this evening as we normally would have, because we have so many distractions, so many things going on. But nevertheless, this program is going to be shared. We're going to put it on, we're going to be sending it out to our membership. In regards to what you're planning as articles and upcoming issues, can you share something with us about that?
Yes, absolutely. You know, as Nick mentioned earlier, one of our PAL directors, Alan Reineck, was the trial attorney for the Groff case, and he is just now finishing up an article for the September-October issue of Liberty magazine, which is really going to go in depth into the story of Mr. Groff and sort of take us step by step through his struggle to have his case dealt with. And, you know, I love Alan's style. He's very down to earth, very articulate, very picturesque in the way he tells the story. And I think people will really enjoy reading about the Groff case from the perspective of someone who was intimately involved at each step of the way. So we're going to have that. We're also going to have, you know, you asked Dr. Martin about what individual church members who are facing these problems in the workplace, what they should take away from the Groff decision. We're going to have a piece in the September-October issue of Liberty magazine, which deals with that, which helps individuals who are facing these difficult situations with their employer. You know, what steps should they take? What rights do they have? And how does the Groff decision change that equation? So they're just a couple of the articles that we're going to be running in the short term. In the longer term, we're going to keep hitting on this issue. I mean, Liberty magazine has been around for 120 years, and we have been dealing with discrimination on the basis of religion because of our Sabbath keeping for every one of those 120 years, and that will continue to be a focus going forward. I just wanted to say also, Dr. Martin, you know, Liberty magazine appreciates so much your leadership in the Northeastern Conference and your partnership with Liberty magazine, and in really getting the word out that Liberty magazine is there as a tool for church members, as a way for church members to connect to people of influence in their communities. They can take Liberty magazine to meetings and say, this is what our church believes on you know, issues of public policy touching on religious freedom. I want to introduce you to Liberty magazine. And it's a great way to make connections. And, you know, we're looking forward to working with you and your team there at Northeastern for many years going forward. As you know, together we really focus on reaching what Ellen White called a neglected mission field, which is the people of influence in our society. That is an unentered territory that we really need to evangelize. So thank you, Pastor Dr. Martin. We really appreciate the work that you and your team are doing in this area.
Thank you for putting together such an outstanding publication, which means so much to us as a church in our community. There's something that we're looking at doing, and I know Lawrence said, we got to wrap it up. Lawrence, give me a couple more minutes, then we're going to be done. And that is, I shared with my team the importance of us putting this magazine in the hands of the clergy in our city. I'm not talking about Adventist clergy. I'm talking about clergy of different denominations. All right. It's a great magazine. I've been looking at the issues. Never used to look at it before. I'm looking at it now, you know, more than ever. Great magazine. You're doing a fantastic job. And I think, and I know y'all see to it that members of Congress get it automatically. We want to make sure we spread this to other civil leaders in our city, as well as the clergy, so that they can help. One of the things we've started, and I'm asking the members out there, I'm still going to do it now, and that is we're asking our members to contribute. Even if they don't have individuals who they want to send a magazine to, send us some money and we'll send it. All right. Because there are a lot of people who asked us if they do to donate to the cause of religious liberty. and we told them to send us some donations. So anybody out there today listening to us, you can continue to send donations to us so that we can use those donations to strengthen our Liberty Magazine subscriptions and get the word to our community. People really want to know about that. So I want to make sure we convey that and get that across. Other point, and as we wrap this up, and that has to do with future programming. And when I spoke with the team today, I suggested them that we divide this into several parts. The Supreme Court made several rulings. One on the case that you discussed eloquently this afternoon, but they made other rulings in regards to affirmative action. There's a lot of discussions now going on about that, because even though it had to universities and colleges and so forth, unfortunately, there's some individuals now applying this to the corporate workplace. You know, there's some forces out there that's doing that now. So this is a very broad topic, and we look forward to coming back in September to deal with affirmative action and the implications of this present decision, the history of affirmative action, where it's going, and the fact that our country now feels that we no longer need it. And so that is a very important discussion that we're looking for having in September. And then in October, we want to do something with on the LGBTQ community and the rulings that came down so that we can have, our membership can have a broader understanding of what's transpiring here. Once again, on behalf of our conference administration, I want to thank all of you for coming and for being part of this program. I want to thank those who are watching us and listening and so forth. We're grateful for it. We know we're pressed for time because there's so many things happening in regards to evangelism this summer. Thank you, everybody. God bless you. And we look forward to getting together again in September. I'm going to ask for our North American Division Director to give us our closing prayer.
Thank you, Dr. Martin. Let's bow our heads. Most kind and gracious Heavenly Father, we thank you for all that you've done here with us. And we just ask, Lord, that in all that we do, that we make it clear that it's about elevating you and not elevating self. Be with us, Lord, as we battle through these things while we tarry, but you've already made clear how this ends, Lord, and we're going to make sure that we're preparing our people to hopefully one day see you in glory. In Jesus' name and for his sake we pray. Amen.
All right. Thanks, Dr. Brown, for your leadership. And thank you so much. All the other facilities let's say thank you to Elder Ashmead and all the rest of you. God bless you. Enjoy the rest of your evening.
And if you missed any aspect of the program, you can go back and watch it on QVT Family YouTube channel. It will be there in its entirety. Thank you so much.
All right. Good night. Good afternoon, everybody. Bye-bye.